Good evening, everyone. For the record, my name is Angie Brewer, and I'm a senior planner with Deschutes County Community Development. I think you can see on the screen right now a PowerPoint presentation for tonight's hearings. There are two items before the hearings officer. The hearings officer is Gregory Franks. And the case planner assigned to these cases this evening, so you'll see my email address and contact information a couple of times throughout the presentation, but I will repeat it at the end as well. All right. So tonight's hearings are the continuation of hearings initiated December 8th, 2021. And as discussed on December 8th, a staff memorandum dated December 17th has been placed on the record summarizing the discussion and reasons for continuing to this evening. New information and emailed comments have continued to come in all the way up until this evening's hearing, and they continue to come in as we speak. They'll be added to the record as soon as possible. The first item on appeal this evening is administrative approval file 247-21-000637-TP, the tentative plan review of 108 single-family dwelling residential lots in Phase A2 of the Thornburgh Destination Resort. The appeal file name on that is 247-21-000948-A. The second is an appeal to the administrative approval of file 247-21-000537-SP, site plan review of the resort's Welcome Center, Gatehouse, Golf Clubhouse, and Community Hall and associated parking. The appeal file name attached to that is 247-21-001009-A. The staff would like to note for the hearings officer, the parties, and the members of the public that the applicant withdrew appeal number 247-21-000998-A following the December 8th hearing. Staff has maintained a consolidated record as agreed upon at the December 8th hearing, but would like to acknowledge that moving forward, this matter will be limited to appeal file number 247-21-001009-A. So I'll jump on down to the hearing procedure here. The procedure we're going to follow this evening is that I will walk everyone through how to participate by Zoom and by telephone this evening, and we do have one person in the building with us physically. There is a note in here that we'll present a memo to the hearings officer. That is on the record and available if the hearings officer would like me to walk through that December 17th summary. I'll leave that up to the hearings officer if he'd like me to do that. The hearings officer will provide his instructions for this evening. Staff will provide a brief report. Applicant will be able to provide testimony and evidence. Any interested persons that would like to testify and present evidence would be able to do so. The applicant may present rebuttal testimony. Staff is afforded an opportunity to make any closing comments, and there is a discussion about open record period. To be clear, there are two separate public hearings this evening. Comments made are unique to the hearings they've been shared to. If you participate in the first hearing, but you'd like your comments to also apply in the second hearing, you may do that. Please just make sure it's very clear to the hearings officer and to staff that you wish your comments to be included on both records. That is an effort to reduce redundancy and the length of the hearing that was agreed upon at the December 8th hearing by all of the parties. So we're hosting this evening's hearing by Zoom, by telephone connection to the Zoom platform, and in person at the Barnes & Sawyer room located at the county's administrative offices at 1300 Wall Street in Bend. If our internet connection is interrupted for any reason, we will attempt to get back online as soon as possible. If this happens, please give us a couple of minutes to activate the public hearing before you attempt to link or call back in. If your own connection gets interrupted, please attempt to join us back using the same link and phone number you used initially. And remember, if you're participating by telephone, you might need to dial *6 to unmute yourself when you're called upon. I apologize, got a little tickle. In Zoom, there's two categories of participants, panelists and attendees. As a panelist, your microphone and video will be active for everyone to hear and see you. And as a panelist, you will have the ability to mute your microphone and turn off your camera, which I'll describe here in a minute with a visual aid. As an attendee, your video and audio will not be active. This is important to note for everyone, because if you'd like to provide testimony by Zoom, you'll need to be promoted to a panelist so that your audio and video can be heard and recorded. There will be a few moments this evening when all participants are elevated to panelists to allow them to identify whether or not they'd like to testify. If you do not wish to be heard, please make sure you are muted and your camera's off at that time. So you can see on the screen, if you're participating online, there are a few symbols. The symbols on the left are your camera and microphone. You can toggle those on and off by clicking on them. And in the middle of the screen, there's a small hand icon. You can click on that to raise your hand and indicate that you're interested in providing testimony. Depending on the number of participants this evening, the hearings officer may wish to set time limits on testimony. We've done that in the past, and if the hearings officer would like recommendations, we can provide that. With respect to oral testimony this evening, the hearings officer and staff are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior that is inappropriate will be addressed and may result in that member of the public being removed from the hearing. In addition to oral testimony, you may submit written testimony at the hearing. If you're in person, please submit your written testimony to me prior to the beginning of your testimony. If you're participating by Zoom or telephone, you can submit your written testimony by email. And my email is on the screen. And again, it will be available at the end of the presentation as well. Please keep in mind that if your submittal is more than 20 pages in length, includes any color figures, or includes any documents that need to be printed on a larger than 8.5 by 11 paper size, you'll need to submit that testimony electronically and as a hard copy. At the conclusion of the hearing, we'll repeat these guidelines for everyone, and as well as the open record period. Mr. Hearings Officer, this is the time where I ask if there are any objections to this format using Zoom and telephone for this evening's hearing. And I think we ask for folks to raise their hand if they have objections. Is that correct? If anyone has any objections, you could raise your hand, and I will monitor the participant list here. I'm seeing none. So at this point, I'll turn the hearing. Oh, I'm sorry. Ken Katzeroff has raised his hand. Can we elevate him to a panelist, please? All right, I think you are a panelist now, Ken.
I'm sorry. Can you hear me?
Yep.
Yes.
Okay, sorry. I don't have an objection. I just had a clarification. I was under the impression we were doing one hearing tonight that was consolidated.
That is correct. Mr. Katzeroff, I'll talk about that,
Okay.
and clarify that. Then if you still have an objection or need a clarification,
No.
you will be given an opportunity to express.
Thank you, sir.
Thank you.
Okay, well, I appreciate the clarification, and your timing is good, because I am now going to turn the hearing over to Hearings Officer Gregory Franks, and I will, I'm available at your discretion.
Thank you, Ms. Brewer. I appreciate it. I welcome everyone in the public to the hearing, as well as the participants. My name is Greg Frank. I am a hearings officer on contract with Deschutes County. Today is January 4th, 2020. It's a little after 6 p.m. And as Ms. Brewer indicated, for the most of you, we're conducting this hearing via the Zoom platform. The cases, and I know some of this is repetitious, but I'm going to get to things that I think are important to you in just a sec. The cases that we're dealing with originally, one of the appeal cases started out as 247-00637-TP, a tentative plat approval for what I believe to be Phase A2, and that has been appealed as number 247-000-948-A. The second appeal case tonight started out as 247-21-00537-SP. It is a site plan request for a number of physical improvements on the Thornburgh Resort property. And the appeal number on that case is 247-21-000-948-A. 998-A. Ms. Brewer, I am going to ask, and just not because I'm just going to ask, I want to make absolutely positive sure that there is no longer an appeal 1009-A to be considered this evening.
It's the opposite. Tonight, we're hearing, it's 998 that was withdrawn. 1009 is still alive.
Then I'm going to ask. So the 247-21000-537-SP, the appeal number is 1009-A, is that correct?
Correct.
Okay, thank you. This is a continued hearing from December 8, 2020. A number of folks who are here this evening participated, or at least were present at that prior hearing. That prior hearing was recorded, and you can certainly go back and listen to it and watch that. And this hearing will be the same. It will be a recorded quasi-judicial hearing before a Deschutes County hearings officer. What Mr. Katzeroff had a question about, and I anticipated that saying this twice would make sure that we all understood where we were going, is I want to talk about the separate hearings, but we now call them consolidated hearings, okay? So I just want to make sure we all understand and it's clarified as to what that means. First, let's talk about testifying, all right? And here's the way I look at it. And if you have any questions when you do testify today, and everyone will be given an opportunity, if you do have any questions about it, just ask me, and I will do my best to explain. So anyone wishing to testify this evening will be given an opportunity to do so. Your testimony is important to me. If you have testimony that's related to both the site plan for the improvements and the tentative plat for the subdivision, if you wish your testimony tonight to relate to both of those cases, a request by me. It's not mandated, but it's a request. Would you do me a favor and just tell me that your testimony should be applied to both cases? That's a matter of courtesy to me. It allows me to make sure that I apply correctly your testimony. If you only intend to testify on one of the appealed cases tonight, my request to you would be that you identify which one it is. And you can do that by number. You can do that by it's a site plan one, or it's a tentative plan one, or it's about the welcome center, or it's about the lots. Help me know what you're talking about. So if you're only talking about one of them, you get to testify, but if you could help me out and just let me know which one that you're talking about. Now, the reason I emphasized the testimony is that what I'm going to talk about next, which is documents, submission of documents, is going to be a little different. And so this part, if you have any questions, once again, ask me. If you intend to submit a document into the record this evening, here's what you need to do. If the document relates to both appeal cases, make sure that both appeal case numbers are on it, okay? Make sure both appeal case numbers are on it. If you only intend your document to relate to one of those appeal hearings, make sure that your document reflects that number or some way I can identify where it goes. So testimony is a request. Please tell me which one it is, or both. If it's a document, then it's not a request, it's necessary. You need to tell me which case or both cases that you are referring to in that document. From a practical perspective, this recording is going to go in both cases, practically. As a practical matter, documents related to one case aren't necessarily going to go to the other case. And you need to keep those things separately. So the testimony, we consolidated very much. The document, where they go into which file, they're still separate, okay? And if you have questions, please don't hesitate to ask me when you testify, and we'll make sure. And I will repeat it a couple times throughout this hearing, because I don't want an inadvertent or a mistake made that you intended to do something, but you're nervous or you testified quickly and you forgot. I don't want that to happen. Let's make sure we get your documents in the right place. For anyone who didn't attend the December 8th, 2020 hearing, this consolidated hearing process was agreed to by the county. It was agreed to by the applicant, the appellants, and the hearings officer. So at least that group agreed to this process, all right? Not maybe if you didn't show up there, you may not have agreed to it, but it was agreed to by that group. The reason, in my opinion, at least that's what I heard on December 8th, was that I have heard a couple Thornburgh cases, appeal cases, and the first appeal cases that I heard, we had hearings back to back. And so the people who testified in the first hearing were required to stick around for the second hearing if they intended to testify for that. And I looked at my notes following those hearings, and I think we finished around 11 o'clock that night. It was pretty late. All right. And I think the applicant, the appellant's representative in this case, and the staff all agreed that having people have to wait an hour and a half or 2 hours or 2.5 hours to testify is quite a burden. And we're trying to help you not have to stay up quite so late. So that's sort of the reason why we're doing it the way we are tonight. At the December 8th, 2020 hearing, I outlined all of my prior contacts with county staff, the applicant's representatives, the appellant's representatives, and from my perspective, nothing has changed since the December 8th hearing. If anyone objects to my hearing the cases tonight based on bias, conflicts of interest, or ex parte context, I'd like you to raise your hands now, and I'd instruct the county to make sure that everyone is given an opportunity to raise their hand, and if somebody does, I want to hear what they have to say.
Mr. Hearings Officer, there are no hands raised currently.
All right, then I'm going to proceed to hear these cases. I'm going to make some suggestions, and once again, it's a matter of respect, and it's that I respect you're taking your civic duty seriously and showing up, whether it be on Zoom or in person or on telephone. I take your duty seriously, and with that in mind, the respect is that I think that going on and on in testimony, especially repetitious testimony, doesn't serve the best interests of all of us involved. So I'm going to suggest the following time limits, all right? And I certainly anticipate at least the possibility of an objection from either the applicant or the appellant's team, but I'm going to stick with the 30-minute total for applicants, 30 minutes for appellants, and the applicants are going to be able to, and correct me if I'm wrong, Ms. Brewer, are we going to ask the applicants to testify first and the appellants to testify next, and then do that all over again? Because obviously my question for those of you who are listening indicate that I haven't prearranged this with anybody. I just want to make sure. I would appreciate that the applicant present both cases, one right after another, in a total of 30 minutes. And I would propose that the appellant present their two cases back to back within 30 minutes. Is there any objection from the county on that process?
None from us, sir.
Okay, how about let's elevate Mr. Kleinman and Mr. Katsaroff and just make sure this isn't a discussion to go into other things. It's just, do you have any objection to, number one, the time limit, and number two, doing your presentations on both cases back to back?
We're in the process of elevating them.
Thank you.
I see Mr. Katzroff.
We think that we're going to keep our entire presentation for both cases to 30 minutes total, with most of that probably being reserved in rebuttal. So totally fine with that on our side. Thank you.
Thank you. Mr. Kleinman?
Okay, thank you. It took me a while to get that
Mr. Kleinman, I
organized.
don't see you. I can hear you.
Yeah, I started the video. Let's try it again. That should work. There we
Oh,
are.
I see you now.
Good evening. No objection to that procedure, and I want to suggest something specific, if I may, so we can arrange for that. Within that 30 minutes, taken together for both cases, we have an organized presentation for myself, John Lambie, the water rights examiner, and Carl Anuta, the water attorney for Ms. Gould. So we'd like to present together in both cases in that order for 30 minutes, and I believe later on Ms. Gould will have some comments of her own.
I appreciate that, and I have no objection to that, Mr. Kleinman.
Thank you.
All right, so we're going to proceed on that basis. So for all the rest of you who are listening or watching this, the applicant's team will have about 30 minutes. The appellant and appellate's team will have about 30 minutes. All other persons testifying, whether in support or in opposition, will be limited to 5 minutes each. Now that's a suggested limit. If there is a slight deviation from that, I'm not going to just stop your testimony, but I would appreciate it if you could keep it in 5 minutes. If you think you're going to need more time, would you at the start of your testimony indicate that fact for me? So let me go through the rest of my comments. I use this, or say this in each and every hearing, but I think it bears repetition because there's a number of folks. I have a participant list that I have access to, and there's some names on there I just don't recognize from prior hearings. And so I want to make sure you're on equal and stable ground with the rest of us. As a hearings officer, I have not done a site view. In other words, I haven't gone out and looked at the Thornburgh Resort property. I haven't done that. And it's my general practice not to do that. My awareness of the property that's subject to this case comes from my review of the materials in the public record. And the reason I do that is simple. You know what's in the public record, and I know what's in the public record. And when I first started as a hearings officer, I used to go out and look at property. And I have to admit, it on occasion would give me impressions that I wasn't even aware of. And I don't want to form my decisions on anything other than what's in the public record. So if you ask, I'm not going to do a site view, but I just want you to be aware of that. The documents that I have reviewed in these cases so far included everything and anything that was submitted in either the precursor case, as I call it, the original tentative plan, or the site plan cases. I looked at all, at least on a cursory basis, each and every one of those documents, and I've reviewed the appeal file for each of the cases as of 3 p.m. today, all right, January 4th. There wasn't actually, as of 3 p.m., I hadn't seen anything new in the record, but that's what I have looked at, and that's what I've done. My job in a land use case as a hearings officer is to consider all laws, whether they be federal, state, Deschutes County, that apply to these cases, and in that context, consider all relevant testimony and written submissions. The task of a hearings officer is to confirm what laws are relevant and then consider the testimony that affects those relevant laws. The burden, as Mr. Kleinman is certain to point out, only because I read it not less than about an hour ago, the burden always rests on the applicant to prove their case. In Deschutes County Code 22-24050, it says throughout all local land use proceedings, the burden of proof rests upon the applicant. And just wanted you to be aware of that. Testimony should be, I don't require it, but should be directed towards the laws, the rules, the standards set forth by the planning staff in the decision and notices, or if you believe either additional or different laws, rules, or standards apply, then I need you to identify those and how they apply. So this isn't necessarily a general opinion kind of decision-making process. This is a relevant law and the facts that relate to those laws. Often during a public hearing like this, a person will state the same or similar facts or arguments that you were going to say. With that in mind, let me remind you that what is important to me is the substance of an argument, the facts or legal justification, and not the number of times that an alleged fact or a legal position is stated. Repetition doesn't make something either more true or less true. If somebody's already stole your thunder, it's okay to say, I agree with that person's position, or I agree with the facts or arguments stated by that person in prior testimony. I take really good notes, and I will leave, based on Ms. Gould's testimony a couple of hearings ago, I will leave my camera on 100% of the time. I'm not going off and leaving. I am going to be sitting here and I'm going to be taking my notes of whatever you have to say. So I take really good notes. I would just want you to be aware that if my notes aren't complete enough, I, on occasion, will go back and look at the recording just like you can and make sure I got your point or your facts or your argument correctly. Couple things and then I will be done, and then pretty much it's your hearing. Failure on the part of any person to raise an issue with sufficient specificity to afford the hearings officer, that's me, or other parties, that's you, to this proceeding an opportunity to respond to an issue will preclude an appeal on that issue. I need you to be really pretty specific about what you are arguing and give me an opportunity to knowledgeably respond. Just a general comment makes it really difficult for me to respond sufficiently. So additionally, the failure of the applicant to raise constitutional or other issues relating to the approval with sufficient specificity to allow the hearings officer to respond to the issue precludes an action for damages in circuit court. The order of testimony. So here's the playbill for tonight's play. First, staff will present a summary of its administrative decision, and that may be as long as staff desires. Next, applicant will give their testimony, and then supporters of the applicant, those who generally agree with the applicant's position, will be given an opportunity to speak. We've already talked about the applicant's time limit, and then anyone who testifies in support will be on the individual person's time limit. Following the applicant, then I will hear the opposition. And to be honest, to start with, I want to hear from the appellant and appellant's team, as Mr. Kleiman has described. If there is any person that's neutral, and I've been doing these hearings for Deschutes County for 2 or 3 years, if you're neutral, testify wherever you want to testify. Either testify in support, testify in opposition, but just make sure you explain your point, okay? I hope I have the ability to figure out which side you're on, and if you don't have a position, just want me to have information, I will try to figure that out as well. Following the opposition, I will ask the staff for any closing comments, and finally the applicant for any rebuttal. I'm not precluding staff from giving additional comments, nor am I precluding any rebuttal by the appellants. We'll see how that goes at the end, because I want to make sure our record is clear. Finally, any person may request the record to remain open. And if someone believes this would probably be Mr. Katzroff or Mr. Kleinman or Ms. Brewer, but if anybody disagrees with what I'm going to say now, I need to know that pretty early. All right. Any person may request that the record remain open. So if you're testifying tonight, simply say, I want the record to remain open, or I don't want it to close tonight. I hope I can figure that part out. But if you make that request, then the record will remain open. Typically, based on my experience with these cases, it's probably going to remain open for 7 days for new evidence, 7 days for rebuttal evidence, and 7 days for applicant final argument. That's typically what happens. Right now, the record will close tonight unless someone makes a request for the record to remain open. Only one person only one request need be made, all right? In the past, not in these cases, because the parties to these cases are pretty darn sophisticated. But in past cases I've had where a second person says, I want the record to remain open, and therefore it doubles the time that the record has to stay open. That's not the way it works. There's a statutory provision, and I'm stuck with it, and unless the parties agree, particularly the applicant, then I would likely just simply do the 7 days for new evidence, 7 days for rebuttal evidence, and 7 days for final argument. So once somebody's asked for that record to remain open, then I commend you, I ask you to either go back and look at this recording or stay till the end of the hearing. Because at the end of the hearing, we will talk about the logistics of date, time, and how you get information into the open record. Ms. Brewer will talk about the logistics, and I will talk about the timing. All right? So those are my comments. This would be the time and the place for Ms. Brewer to give the staff comments. Following Ms. Brewer's comments, then I will be looking to the applicant or applicant's representative. Ms. Brewer?
All right, thank you, Mr. Hearings Officer. If the producer could bring my PowerPoint back on, and just a quick note that my PowerPoint anticipated a slightly different sequence of the slides than what we've agreed upon, so there might be a couple of extras that I just skipped through. So let me get up here to the first slide for the public hearing for 637. My presentations are fairly brief. They rely significantly upon the staff reports provided produced for the administrative decision for 637 TP and 537 SP. As we've discussed a few times in this evening, 637 TP was the tentative plan approval for a portion of Phase A2 subdivision that includes 108 single-family residential lots planted in 4 phases. The applicant was Central Land and Cattle LLC and Cameron Delashment, and the appellant was Christine Larson. And just briefly, I can provide just a vicinity map here, a snip of the site plan, so people can orient themselves as to what part of the proposal this specific development is proposed to occur. It's in the southwest corner, and you can see. You might have to squint on your screen, but you can see the individual lots as they are proposed for single-family residences. We did not produce a new staff report. I think I noted that already. And the administrative decision does include extensive conditions of approval to ensure compliance with all applicable rules, regulations, as well as the final and conceptual master plan documents that were previously approved. The appeal provided for this administrative decision was number 948A. And just briefly summarized here by staff, it included 15 points of reasons for appeal. The appellant cited an error to rely upon decisions that are not yet final, which specifically was the golf course and lakes decision. There's a lack of compliance with the final master plan conditions 10 and 38, and therefore substantial modifications to the final master plan approval. The decision fails to adequately address Department of State Land's comments. The findings regarding the final master plan conditions 1, 10, 21, 28, 33, 38, and 39 are in error. Findings on page 22 of the staff report do not fully address ORS 92.09.0 sub 6. Substantial changes to the approved conceptual master plan. A lot of record issues are not adequately addressed by the staff report, and incorporation by reference of unattached documents was deemed unreasonable by the appellant. So that was the first item for 637 and 948. And we'll skip through some of these. And the second for 537 SP, the site plan. We, same circumstances, we did not provide an additional staff report for this. We rely upon the findings of facts and conclusions of law in the original staff report. The request was a site plan review of the Welcome Center, the Gatehouse, Golf Clubhouse, Community Hall, and associated parking. And the same applicant, Central Land and Cattle and LLC and Cameron Delashment. And the appellant in this case was Ms. Annunziata Gold, represented by Jeffrey Kleiman. Here's another site plan attached to that specific decision. You can see that it's essentially the development on the southern half of the destination resort. And there's a few arrows there, the Community Hall, Clubhouse, Welcome Center, and Gatehouse. And the appeal, the reasons for appeal are summarized by staff, is that the original tentative plan for Phase A1 remains under review. The lot of record status has not been adequately addressed. There's a failure to comply with final master plan conditions 10 and 38. A failure to condition building permits upon compliance with the final master plan conditions 10 and 38. The applicant does not comply with final master plan condition 28. The applicant has not demonstrated compliance with the use of Bureau of Land Management property for access. And Mr. Hearings Officer, that concludes staff's brief presentation of both cases, available for any questions you might have.
Thank you, Ms. Brewer. I don't have any questions at this time. This would be the time and the place for the applicant or applicant's representative. Please identify yourself once again for the record, please.
Yeah, just in case. Thank you. You're elevating them. I see Mr. Katzaroff.
Okay. For the record, Ken Katzaroff, I'm an attorney at Schwab, Williamson & Wyatt, and I'm here on behalf of the applicant, Cameron Delashment. My address is 1420 Fifth Avenue, Suite 3400, which is important if you want to get something to me, and Seattle, Washington 98101. Like I said earlier, I'm going to keep my remarks fairly brief, and this relates to both files or both appeals that we're working on right now. I'm going to try to keep this under 5 minutes, certainly. First thing I'd like to say is that we filed a pre-hearing letter yesterday. I'm not sure if the hearings officer had a chance to see it or not. No worries if not. It addresses appeal issues for both files. And there's just a couple of quick things I want to chat about. The first being I made a clerical error myself, and I inadvertently referred to the 537-SP or the Welcome Center site plan as the OLU decision. For those folks who are following Thornburgh, that it's not surprising to make that mistake, and instead that site plan should refer to Welcome Center. So where I say OLU decision, it still refers to the Welcome Center. So I just want to make that clarification. The second I'd like to talk about is a couple of quick corrections that we would request to the decision whenever the hearings officer issues his decision in this matter. Primarily, these requested conditions relate to incorrect conditions being placed into the decisions themselves. And what I mean by that is that the staff decisions improperly used conditions from the conceptual master plan or CMP and not the conditions of the FMP or final master plan which in fact replaced or supplanted the CMP conditions. We dealt with this in the last process as well, but for clarity's sake and attached to the letter I filed yesterday, we've taken the administrative decisions and either struck the conditions that were previously struck in the final master plan approval, or struck them and provided comment consistent with the final master plan decisions by Hearings Officer Briggs from 2008 and Hearings Officer Dan Olson from 2018, which imposed the correct conditions. So hopefully we can make those changes so that we actually have the correct conditions that apply. The second thing I'd like to ask for a correction on is, it's not really a correction per se. In the last month, this hearings officer issued a decision to approve a final master plan modification related to OLU, certain ratios, weeks, and things of that nature. And so that impacts condition, final master plan condition 21 and 35. Which are both applicable criteria in this decision. So we would ask for those conditions just to be updated to reflect the modifications as they exist today. Couple of other quick things. Actually, I'm going to stop there. I'll say, for the most part, besides that and what's in our letter, we think staff did a great job on these decisions, and we look forward to providing additional comment and rebuttal, and if the record remains open during that process as well.
Thank you, Mr. Katzeroff. Appreciate your testimony. Is there anybody else on your team that's going to testify at this time?
Nope, we're gonna wait for rebuttal.
All right, thank you.
Thank you, sir.
Is there anyone wishing to testify in support of I will just say the applicant's position, or what Mr. Katzeroff is proposing, or the applicant is proposing?
I'm not seeing any hands raised, and we do have one person in the room, and he's shaking his head no. So no one has indicated.
Thank you, Ms. Burr. Mr. Kleinman, I'll let you MC this. You're on with respect to the appellants. And would you do me a favor when you first start out, is both give your name and address, but also indicate, are you representing Ms. Larson and Ms. Gould, or one or both? I just want to make sure I know who's representing who here.
You're on mute, Mr. Kleinman.
Okay, Jeff Kleinman for the record. I am representing Ms. Gould in both cases, and, pardon me, and testifying in both cases. My address is 1207 Southwest 6th Avenue, Portland, 97204. I am going to request that the written record be held open for 7+7 plus 7 in the traditional manner, and I think that's going to be sufficient in this case. And as one preliminary matter, we do oppose the requested amendments to conditions 21 and 35 of the final master plan that were just proposed by Mr. Katzeroff. He is correct that those were revised in the recent case that he described, and that case is now on appeal to the Board of Commissioners, so that change has not taken effect. I'm going to try to be brief myself. As I indicated, we'll have our certified water rights examiner, who has a number of other licenses, John Lambie, testify next, and Carl Anuda, who is an expert on water law, testify after Mr. Lambie. So we have provided detailed memoranda today in both cases, and it is not my intention to walk through those one more time. I know the hearings officer will review them. I want to make a couple of key points. The first is that condition of approval 10 of the final master plan requires documentation of the state water right permit at each phase at each tentative plat at each site plan application, and it's required to be via documentation. The applicant contends that it's been decided that's an informational requirement. We don't necessarily disagree with that. The question is, what the heck is the information? And where's your documentation? And the information and the documentation are that there is no usable water right for either of the applications that are before us tonight. None. And for example, if the applicant were allowed to proceed and develop pursuant to the site plan for the clubhouse, the welcome center, etc., the landscaping for their parking lots, they could not lawfully turn on a tap. That's the story. And we shouldn't be looking at or relying upon fictions or facades as to the status of the information or the documentation of the original water right permit, which is described in condition 10. One cannot do that. And I'm going to say that's especially true as to the site plan applications, so that even if the case law is correct as to the applications that precede the site plan, that the issue is whether one is legally precluded or not. And that's an issue that's been addressed on appeal in this case. When you get to the site plan, that is not the law, because that is the final stop. And you have to have the water, not just not be legally precluded. Are you going to wave a LUBA opinion in front of the tap and have water come out? No, that's not the way it works. You must have the water permit. It must be in effect. You must be able to draw water. In this case, there is no ability to do that. And the applicant, recognizing that its contested effort to extend the permit described in condition 10 of the final master plan may well fail, has, as the record shows, and as the following witnesses will talk about, applied for a whole bunch of other water sources for its municipal water supply, each of which would have different impacts and require a new analysis and a revisiting of the conceptual and final master plans. So that's where we are. They cannot turn on a tap, and that means they are not in compliance. I'd just make one other point to you, and it's related to the issue I just discussed, and I'm going to be very, no pun intended, frank about this. But we have presented the history of the development and final adoption of final master plan condition 10 and condition 38. They are intertwined and interlinked. They were the result of a very lengthy appeal process and the active participation, not just of the county and the public, but OWRD and especially ODFW, which had to be satisfied. So the mitigation referred to in condition 10 is in significant part the mitigation described in condition 38. And we have provided, as I say, detailed history on that. There has been a very strong effort by the applicants to brush all that aside, to rely, in spite of their knowledge of the history, at least referring to the applicants as the actual parties, not their attorneys, their actual knowledge of the history of how all this came about since before 2008, leading up to today, 13 years later. That the only issue on the water supply is whether they're legally precluded, and that the mitigation really refers to nothing, and they don't have to prove it. Those are frankly outrageous contentions, and it is really not acceptable for the county to go along for the ride on those. So with that, and again, with the understanding, as always, that the hearings officer is going to read everything, which is not the most pleasant of tasks. I'm going to pass along the mic, as it were, to Mr. Lambie.
And before,
Yes.
before I do that, and Mr. Kleinman, for those of you who are listening and don't know either him or myself, have had prior cases when I was employed as a hearings officer at another location. So we have a fairly extensive background, and I think he would agree with me that these cases, the Thornburgh cases, would be probably considered a little unusual, both in the number of hearings, the number of appeals, and the number of decisions rendered in a particular on a particular project. So I think he would agree with me. If he doesn't, then I guess we have a point of departure. But the reason that I bring it up, Mr. Kleinman, and our background is to make a point to everyone who is listening to this that the Thornburgh cases are just a bit unusual in at least the number of cases that are involved in a single project. But because there's been a number of cases on a single project, there's been a number of prior decisions. And in this particular instance with this hearings officer, I've made 3 of those decisions. And what would be interesting and most helpful, Mr. Kleinman, from your perspective, I would hope, is that a number of the arguments that I read in Ms. Gould's appeal statements, which were attached to her appeal documentation, and also summarized by staff, appeared to me to overlap. And I'm not saying that they're the same, and I'm not saying that they're duplicative, and I don't want any negative connotation to them. But they do seem to overlap. The condition 10 argument, the condition 38 argument, the lot of record argument, and others. What would be most helpful, and I'm not trying to coach your side, but what would be most helpful to an objective hearings officer would be to have you clarify, distinguish, differentiate how your arguments are different than the arguments that have been made in prior cases that I've been involved with. I'm not suggesting that you go back to the beginning of time, but what is concerning to me is that there are 2 options, at least simple options, to these 2 appeals. Either I agree with you, or I agree with the applicant, or some combination of those things with specific issues. And what I would like to do is that I think consistency has merits, but being consistently wrong is not particularly something that I would like to be. So making the same arguments is certainly acceptable on your behalf, but on arguments that you know that I have rendered decisions on, it would be most helpful if I knew why specifically those were wrong in your perspective. Because simply going over the same arguments, I don't think serves a real productive purpose for either Ms. Gould or the applicant or anyone else interested in these cases. So that's my request. I don't expect a response now, but I will hear Mr. Lambie, I will hear Mr. Anuta, but it would appear to me without having heard their testimony, that there's going to be some overlap on prior cases or prior arguments that were made. And I'm asking you, when you get ready to summarize, either in writing or orally, that you very definitively point out how these arguments made this evening and in these cases is different or distinct than they were in prior cases.
Right.
I think that's a respectful request. I think that assists both you, but it also clarifies where I'm coming from for the applicant.
Yeah. Let me respond briefly to that so the other witnesses can proceed. And I appreciate the manner in which that request was put, and certainly am in no way offended by it. It's part of my job to answer questions like that. But first of all, the prior decisions are all up on one sort of appeal or other. So they've not finally been decided. But second, I would refer the hearings officer to Final Master Plan Condition 10 yet again, which requires that applicant shall provide at the time of tentative plat site plan review for each individual phase of the resort development, updated documentation for the state water right permit and an accounting of full amount of mitigation as required under the water right, and that incorporates Condition 38. So, among other things, as a result of the independent showing that's required with each application, the doctrines of impermissible collateral attack, which the applicant relies heavily upon at all times, in every case, regardless of what it's about, and doctrine of law of the case do not apply. Second, the facts and the record made here will be different from what you have seen before. And that needs to be taken into account. So that's my primary response, and that will certainly provide you with more later. But the third point is that there is one that I just made in my initial presentation, which is that when you get to the last stage of land use review, as opposed to building permit issuance, and you're dealing with a site plan, in that case, they have the water or they don't. We've got at least one site plan before us tonight. They do not have the water. So the legal standard, such as it is, of not legally precluded from using the water right does not apply. Prove you have the water and can turn on the tap. They don't have it. They can't prove it. So those are my initial distinctions for you. And I appreciate that opportunity, and I've talked too long already. So we'll move along to Mr. Lambie.
Okay, and I have one final question, and it may be because I don't hear as well as I used to. But I keep hearing, I believe, condition N, and are you referring to condition 10?
10. Should I turn up my volume? Is the volume low?
No, it kept sounding to me like N, and I keep looking to my left, which is where the decision and your application materials are, and I keep seeing no N. Got it. Mr. Lambie, you're up.
Hi, thank you. Good evening. I guess I could start off with this is
first and last name and address, please.
Oh, thank you. John Lambie. Address is 4061 Southwest Chesapeake Avenue, Portland, Oregon. Is that enough there?
Go ahead.
Okay, pardon. Not very familiar with these types of hearings. By way of background, I am a professional geologist, professional engineer, and certified water rights examiner. I've been reviewing water rights filings for the Thornburgh Resort since the spring of this 2021 on a variety of matters related to how they would supply water to the resort. And then a subcategory of that is their water rights related to their mitigation water required. So my testimony this evening is on these technical areas where there's insufficient water available for Thornburgh to provide the mitigation water required by them under this Condition 10, where they're in regard to an accounting of a full amount of mitigation as required under Thornburgh's water rights, which is in and of itself another topic, but I'm going to stick to the mitigation water. Now, by way of background, Thornburgh Resorts proposes to provide its mitigation water for its diversions principally by using the flows from a deep canyon creek up at a nearby facility called the Big Falls Ranch. You may well be aware of that, but I feel it necessary to put it in context. Now, Big Falls Ranch holds surface water rights to the Deep Canyon Creek under a transfer that they made of those water rights with Oregon Water Resources Department. But they hold 5.5 cubic feet per second of rights from that source. Now, Oregon Water Resources Department identified that when they transferred that water right to 4 wells, all of those water rights remain surface water rights. The source is surface water. Under this transfer, water is diverted from Deep Canyon Creek via 4 nearby wells. I put through my notes. Now, here's what happens. Deep Canyon Creek is a spring-fed creek. That is its principal source of discharge. It only would receive runoff in an ephemeral rain event that would be very large. So groundwater discharging at a spring or a seep occurs when the hydraulic head at the spring, at the groundwater elevation pressure, if you will, is greater than the elevation head. So when hydraulic head exceeds elevation head and there's a pathway for water to flow out, voila, you have a spring at the surface. The rate of flow of that spring is governed by each of those 2 factors, the pathway, its permeability, and the changes in hydraulic head. Groundwater extraction by a well lowers the hydraulic head, specifically within that well's capture area, and thereby will diminish the rate of spring flow. Now, to date, the focus of my testimony is going to be on the 3 wells that are connected to Deep Canyon Creek, from which the mitigation water is offered by Thornburgh Resorts. Groundwater extraction by Big Falls Ranch, the people they propose to make an arrangement with, has lowered the groundwater hydraulic heads in each of these wells to below that of the Deep Canyon Creek spring. I'll read a few of the points of fact into the record for you. The first of the 3 wells I want to focus on is well 1. Now, well 1 is under its water right for Deep Canyon Creek, and the water right that governs that well is allowed to decline up to 10 feet before it must curtail completely. It is currently lowered 8 feet below that water rights limitation. So that tells you that they're basically on the razor's edge. They're moving slowly and steadily toward the point at which the water level will be deemed by OWOD to be at a point too low for them Big Falls Ranch to continue to extract. Now, their static water level in that same well 1 is now 1 foot below the spring during the springtime reading when the well is not on. So just at static conditions, the water level in a nearby well is 1 foot below the spring. Now, well 3 is the second of 3 wells I'm going to talk to you about. I'm describing wells 1, 3, and 4. Apologize for the numbering, it's not my own. Well 3 is now 7.4 feet below its basic condition. It has the same bracket. It can only go 10 feet below its static beginning in 2001 before they must curtail. Well 3 is currently at static about just barely above the spring elevation. I'll put it that way. When it pumps, when it's on, it's pumping at a hydraulic head that is 57 feet below the spring. So you can well imagine what happens when it's pumping. Moving on to well 4, the third of the wells in this group that are connected to the spring, it is down 8.1 feet since its benchmark. It again is only allowed to decline 10 feet in total before it must be curtailed, and its static water level is now 2 feet below the spring. I've given all these things to you graphically. It's some memorandums that have been submitted into the record, but I wanted to just emphasize some of the points made. Now, these static heads observed in wells 1, 3, and 4 would have to increase above the Deep Canyon Creek spring for open flow in Deep Canyon Creek to be available as mitigation water for use by Thornburgh. So in other words, Big Fall Ranch's conditions of use have to be compatible with a transfer of this water in some fashion to Oregon Department of Fish and Wildlife for the water to be available in mitigation, and it simply is not. So I make the point that BFR, in their most recent transfer application of last summer, demonstrate that, I'm sorry, I'm using the shorthand, Big Falls Ranch, they expect to continue their claim to surface water and to increase the rate of withdrawal. So Big Falls Ranch to date has made no indication that they intend to decrease or diminish their rate of extraction. And here's where it gets really, really tricky, is that BFR currently hold water rights for up to 24 cubic feet per second. Remember I said that the Deep Canyon Creek rights within that is 5.5 cubic feet per second. Now here's the rub. Those Deep Canyon Creek rights are the most senior of the water rights. So when you stack up all those water rights and you say, oh, how am I going to make water available? You can't pull the Jenga block out from the bottom and not expect the whole thing to cascade. In other words, they cannot transfer out the senior water rights from within this stack of groundwater rights without undoing the thing. They simply don't have that 5.5 CFS of water to transact on account of that stacking. I hope that we'll come back to that. So Big Falls Ranch is still diverting the Deep Canyon Creek directly by way of these 4 wells they put it onto, 3 of which are connected to the spring. What I point out is that when Mr. Newton, in some of his earlier assertions of the fall or late summer, he states that there's clarifications on the mitigation water source. The continuing decline in groundwater hydraulic heads indicates that groundwater is being overutilized and the use by Big Falls Ranch is not sustainable at all. So my comment is there's no source of water available physically, let alone that legal description I just gave you, for mitigation. Even a forfeiture or abandonment of the Deep Canyon Creek water rights by Big Falls Ranch doesn't remove the fact that those same 4 wells are impacting Deep Canyon Creek. I'm sorry, really 3 out of the 4. They've transferred them on to 4, but 3 of them are connected to Deep Canyon Creek Springs. And so even if they wanted to unwind it, the impact by Big Falls Ranch usage is still going to be present for those Deep Canyon Creek Springs. I'll stop there because that's where the technical and the legal cross over. Now, Mr. Newton incorrectly asserted that the diversions from Deep Canyon Creek have ceased. It simply has not, either physically or legally. And the actions, as I've stated, sorry to be repetitive, by Big Falls Ranch, unless they were to change the character of their usage of water, would not enable the flows in Deep Canyon Creek to be restored. So I wanted to make a few other points in my latest response to some of Mr. Newton's assertions in October. There are points of agreement which I think are probably useful for the hearings officer to hear about. First, I state that there is no assignable water right for ODF&W to take mitigation water. Because these water rights are now entangled on the wells, there's no way for ODF&W to receive a water right that they can do anything with. Again, it's this Jenga block. They can't transfer out and give ODF&W these rights when these other junior rights are sitting above it. It just won't work. They have to disentangle it, then they can give it to ODF&W, and then ODF&W can put a call on Big Falls Ranch to say, oh no, we need our Deep Canyon Creek water, that nice cold spring water that's not there. And you, the junior right holder at Big Falls Ranch, you have to stop pumping those wells. That's the way they would have to stack up for that to actually work. So without disentangling these water rights, they're just simply not there. And physically, those same wells are diverting from the same water source that feeds those springs. That's a factual point I make that Mr. Newton and I agree upon. When he pointed to some of his earliest analysis at the Big Falls Ranch, he found that wells 1, 3, and 4, the ones I walked you through, are connected to the spring. On that, he and I have no factual disagreement. His analysis demonstrates that when he extracted from those wells, he saw a zone of capture that would hit that spring and does hit that spring. In other words, it impacts the flow from that spring. BFR are in fact physically and legally diverting their surface water right at those wells. Now, Mr. Newton affirms that the 5.5 cubic feet per second required in Deep Canyon Creek is not there any longer. He went out to the site, and from his field visit, he documented there was at most 5 cubic feet per second as he judged it at the weir where they used to divert from. The weir is still there physically. So I simply state that no agreement between these two business partners, Big Falls Ranch and Thornburgh Resorts, is going to return those flows into Deep Canyon Creek. Until extraction is slowed or stopped at Big Falls Ranch's 3 wells connected to the spring flows will remain diminished and the water unavailable for mitigation credit, the mitigation water necessary under this condition 10. It is very important in this case that those water rights which are so entangled be disentangled because of that seniority I've described. I think I'm just getting into repetitive material here. The mitigation water has to be made available for ODF and W to be able to make a call for that water to be there and to provide that reliable, consistent water that's called for under the excuse me, terminology is missing for me. Under the, I'll call it the habitat mitigation plan, or excuse me, here it is. The Fish and Wildlife Mitigation Plan for Thornburgh Resorts. That's the one that requires that this water be reliably available for ODF and W. And I'll stop there. Have you any questions?
No, I'm looking forward to reviewing your written submission.
Very good.
Thank you. Mr. Anuta?
Thank you, Mr. Hearings Officer. My name is Carl Anuta. I am representing Ms. Gould on water issues. My address is 735 Southwest 1st Avenue, Portland, Oregon, 97204. I submitted a many-page document today that includes all 3 of Mr. Lambie's reports, so that you will have those in front of you and you can read them when you have more time. I want to focus for now on some of your questions and some of sort of the high points and the low points, as I would call it, of where we're at. You asked a critical question up front, which is, how is this situation now different than prior decisions or prior situations? And as Mr. Kleiman noted for you, we're at a site plan stage. There's not going to be any more land use review after this that's going to involve somebody checking to see if water is available. So we have to look at what water is currently available. And as Mr. Kleiman noted, and as I've outlined in probably excruciating detail for you by now, in my memo, there is no water currently available. There is an expired water right under which they can pump nothing right now. And maybe somewhere down the road, when that's resolved, if they get an extension, they might be able to pump something maybe later. But it's all ethereal. And they had recently as early December, been given a temporary transfer by the Water Resources Department that they had requested. It's one of the many requests for additional water that they made that Mr. Kleiman referenced. And you'll see in my materials, I list out all the various requests that they made because they know there really isn't any water available under that expired right. Because otherwise, if there was, there'd be no reason for all these other requests. The temporary transfer was issued by the department. There's a lot of arcane water law that I won't bore you with as to why they felt compelled to issue or mistakenly issued a temporary transfer. We've now challenged that temporary transfer, and as a matter of law, that water is no longer available because the order that would have authorized it is automatically stayed by statute. You may recall in the December hearing at the end, Mr. Delashment noted that there were several hundred feet of water that had now been made available to the resort. That's the temporary transfer right, which is no longer available because of the automatic statutory stay. So you are in sort of an unusual position at this site plan level where you have to say, okay, county, you've been sort of kicking the can down the road and saying, we'll get to that water issue and really assess availability and what's there and what's not there later. We're there now. We're at the end of the road from a land use perspective, and they can't kick the can anymore. They have to say, is it available or is it not? And in the record in front of you, it's not, because they can't point to a single place where they have the water available to pump and turn on the tap. And certainly not the place that they have to do under condition 10 and condition 38. Condition 10 specifically refers to that groundwater right. They can't use it, can't turn it on because it's expired. Condition 38, which is the Fish and Wildlife Mitigation Plan that is referenced in condition 10. Condition 38 is the one that says you got to comply with the Fish and Wildlife Mitigation Plan, and that's plan expressly says you got to put these deep canyon creek rights into a permanent in-stream right that goes all the way down to Lake Billy Chinook. So out of the creek, all the way down the Deschutes River to the lake. Everybody agrees that right doesn't exist. So they can't meet that mitigation requirement. Not only does that right not exist, they haven't even started on that process. I've outlined for you in my brief or comments a timeline and a series of steps that they have to undertake to start that process. The first thing they have to do is they have to ask that those Big Falls rights, Big Falls Ranch rights that Mr. Lambie referenced, be transferred back from the wells to the surface water. There has, at least as far as I've seen, and nothing they've submitted so far, although I haven't seen Mr. Katsarov's letter submitted yesterday. But up to this point, there's no evidence that they've ever asked. The only thing that they have put in previous hearings, and not in this matter, but in previous matters, out there is an email where Mr. Delashment says to the agency, how would I do that if I wanted to ask? And the agency says, well, you could send us an email. But there's no email from Mr. Delashment saying, start that transfer back process. And as I've noted in our materials, there's a legal question as to whether they can actually do that because they're not unwinding the entire transfer, they're only trying to unwind a part of it. But that's going to be an issue for the water folks, water resources to resolve. But my point is, there's a whole series of steps that have to happen. You have to get the water back. As Mr. Lambie pointed out, you can't not have it come back because it will be pumped from the wells. So you got to get it back. Then you got to take it as from irrigation use and move it to an in-stream use. And you got to go through a whole process for that. It's not just an email for that. You got to go through the whole transfer statute and you got to make it a permanent in-stream water right. And it's only at that point that they get to compliance with condition 38. So that's sort of the fundamental problem here and why we've got to go about disentangling those rights and why the applicant hasn't met their burden, because they can't prove to you that they've even started disentangling, much less completed that disentangling. Then the other thing I would note for you is we've included in the materials the unlikelihood, and again, it's not our burden to prove that it's unlikely. It's the applicants prove that they will get other water rights, or they have other water rights. They haven't done that. But we've also included the groundwater reviews that the Water Resources Department has done of the limited license, the backup groundwater permit. And those groundwater reviews are all very clear. There's no water available for more appropriation there. The resource is already, as Mr. Lambie pointed out, dropping. And the resource is dropping because there's too many wells out there. And those reviews all note that if the additional use that Thornburgh is requesting now from these additional rights is allowed, it's going to harm state scenic waterway flows. That's one of the things we've said in our challenge to the temporary transfer, is that the agency failed to take that into account. Again, that's not something you have to decide, but I wanted to give you some background and context for this stuff. In the past, there's been statements by the applicant about how they now own that 5 CFS piece of the Big Falls Ranch rights, and they've told Big Falls not to pump it. Assuming, for the sake of argument, that that's true, and we know that they do own it because there's assignments that were put in the record. We don't have any actual evidence that they've told Big Falls not to pump it, but I presume that they did that. But even if it's true, it doesn't protect the water in stream. It just means that the water, if it's not being pumped, is available for the next appropriator in line. That's how first in time, first in right water law works. If you haven't used your water and you haven't converted it to an in-stream water right, the next guy in line or gal in line gets it. So we have a fundamental problem with what the applicant keeps trying to gloss over, the lack of the mitigation water in an in-stream form. And we have a fundamental problem with what the applicant pretending is not an issue, which is there isn't really any water that you can use to turn on the taps. And there isn't water you can use unless you buy it somewhere else to even do the construction. So this is the point where the county should have said, okay, we were willing to go with you on, you'll deal with it later on these other tentative plans and on these other master plans levels. But now we're at the site plan level. Where's your water? We're not supposed to approve a land use if there's no water. That's the whole point of planning, is to not do that. And this, unfortunately, the staff didn't think that through or do it that way. They were instead focused on the other issues. And one thing I thought was really interesting in this whole proceeding is that the staff didn't even, if they wanted to try to kick the can further down the road, they would have at least, should have conceptually said, well, you got to at least demonstrate that you have the water in hand by the time you get to a building permit. But there's no condition that says that. And certainly in reality, the building permit office isn't going to assess and doesn't have the capacity to assess whether there is water available under a legitimate water right for a building that's being proposed. That's not their job. That's the planning's office job. I think the rest of it I've covered fairly extensively in the materials. I would note that one of the things I cited in the materials was a statement by the applicant's land use lawyer, Ms. Fancher, who at one point said in one of her briefs that the Fish and Wildlife Mitigation Plan requires the resort to provide mitigation water in advance as part of any, and then she went on and said that's got to be there as part of a tentative plan or a site plan. And I've cited to the page of her argument for you. Well, last time I looked, that's what we're here for, is a tentative plan and a site plan. So, but there's no proof of that water. There are a number of different documents that I've attached to the materials. The key ones that I'll draw your attention to now before you have a chance to review things are the sort of most troubling for me as a lawyer. in the land use approval process for this resort, the applicant represented that it would abandon 3 existing wells on these properties. ODFW relied on that. The county relied on that. The Fish and Wildlife Mitigation Plan expressly requires that those 3 wells be abandoned. The county's condition of approval for the resort requires that those wells be abandoned. In all of the applications that I reference in the materials, the limited license, the temporary transfer, the permanent transfer, the groundwater backup app, in those applications, the applicant has listed as the source it will draw water from one of those wells. One of the wells that it expressly represented that it would abandon. At the same time, the applicant has repeatedly in those applications proposed to put water on parts of the land that are not within the resort. It's outside of their land use approval. And what's troubling is in the early maps a while back, they actually were careful to distinguish that these parts were not in the resort, and so they weren't going to put water on those parts of land. In the current applications, they're not making that distinction. It appears that somebody's hoping Water Resources won't notice the distinction between the resort boundaries and the lands on which this water is to be applied, or that the county won't enforce the restrictions on where the resort is and where you can put water that you're getting from a resort source. Those 2 things I think stand out because they're not consistent with the land use process. They're not consistent with the conditions of approval. And yet staff missed those or wasn't able to figure out a way to incorporate dealing with those. That's something that needs to be dealt with in your decision, I think, because otherwise the applicant is going to claim, I'm going to go out on a limb here and say that if there's ever another application, they will claim that this issue came up in this proceeding and therefore Ms. Gould or anyone else who had participated is collaterally stopped from raising this issue of an illegal well or a well that was required to be abandoned and now being available for use or putting water outside of the resort. So I would urge you, when you deal with the decision, unfortunately, get into those nitty-gritty details because this is a situation where any detail that is not directly addressed, someone later will claim that somebody can't raise it as collateral attack. I will stop with that. I'm happy to answer any other questions that you've got. I would note that my comments do apply to both proceedings. I would also note that I did not pick up on the fact that the site plan appeal was 1009-A, so my written materials reference the 998-A, and I'm happy to submit a corrected copy if that would be needed for the county's files. But I noticed that when we were talking, Ms. Brewer was talking earlier, that I had the wrong number on part of the listing of the files. If you had any questions, I'm happy to answer them.
Now, I'd ask that you submit an email to Ms. Brewer indicating what you just told me about the incorrect case reference and request that she include those comments in the appropriate file.
I'd be happy to do that.
I'd ask you to do that. Okay, thank you. Mr. Kleinman, anything further before I move on to the general testimony?
Thank you. Nothing further. One thing along the lines of what Carl was just talking about, I noted somewhere in these materials that the applicant now contends that regardless of the contents of FMP Condition 38, they have literally no agreement with ODFW, and I would suggest to them that they go ahead and raise that contention with ODFW because they certainly do have one. That's all. Thank you.
Thank you, sir. This would be the time and the place for anyone in support of the appellant's position or is in opposition to the Thornburgh Resort proposals.
Mr. Hearings Officer, we have
Mr.
a few hands up. Mr. Katzeroff and Mr. DeLashman have had their hands up for a few minutes. I didn't want to interrupt. Do you want them to be elevated before you
I will
receive?
take Mr. Katzeroff first.
All right, he's on his way.
I was just trying to point out the fact that it seems like our time limits are way out of whack. And so hopefully we can address that. I don't want to provide rebuttal at this point in time, but I do want to point out a couple of quick things, if that would be okay. If not, then I will reserve it.
I'm going to have you wait for a rebuttal, and if you recall, my opening comments were that I didn't put limits, strictly limits. They were more suggestions as a matter of common courtesy. Certainly, Mr. Lambie and Mr. Anuta did use more time than I would have liked, particularly since they keep referencing the written materials. And that comment is not to be a dig towards Mr. Lambie or Mr. Anuta. It is meant to be a suggestion that if you submitted something in writing, particularly those folks who are not used to testifying, and Mr. Klein and Mr. Anuta, Mr. Lambie, and certainly Mr. Katzeroff, maybe not Mr. Lambie, because he indicated he hadn't testified a lot in land use hearings. But let me tell you all a truism with respect to whether or not it's judges, if it's a bench trial, or it's a land use hearings officer in an administrative quasi-judicial hearing context. Let me tell you how it really works. Is the hearings are really important, and your testimony is really important, and I appreciate it. But in all likelihood, a judge, or in my case, a hearings officer, is not going to go back and listen to your testimony 2 or 3 times. Let me tell you what really does happen. What really does happen is that if you submitted written materials, and if it has a point that's relevant to this case, I'm probably going to read it 2 or 3 times. And that's just the reality of how this process works, is what's in writing tends to have a longer mental shelf life than even my notes that I have on my screen next to me. And I'm not trying to denigrate in any way, shape, or form any of the folks that have testified so far. But I'm telling you that what you submit in writing will get reviewed. I will read it. I made a fatal mistake one time on the City of Portland Airport Master Plan, just as an anecdote, is that I indicated to a packed house of about 100 in the hearing that I promised I would read everything that was submitted. And an audio engineer came up and testified, and he brought 3 books. God, I'm certain that they cost him a fair amount of money. He gave me 3 books. The problem with the books that they weren't novels. It wasn't Harry Potter. It wasn't something that I was probably going to enjoy reading. They were all technical, audible, or they were related to the audible issues that related to the Portland airport. And quite honestly, in Mr. Lambie's case, or the technical expert's case, if you expect a hearings officer to become an engineer after one night's testimony, and it's not going to happen. But I will try my darndest to understand what you have submitted in writing. And I will do my best to understand what you did, what you submitted in writing. There were a number of things in Mr. Lambie's testimony that simply went over my head. But Mr. Lambie, I promise you that I'm going to read your memos, however many of them there are, and I will do my best to understand those memos. And that's simply human nature. That's the process. And I respect the process, and I hope you do too. So, no, you're going to do your rebuttal during rebuttal, and we will move on to those who have raised their hands and wish to testify in opposition to the Thornburgh applications or in support of the appellant's positions. Thank you, Mr. Katzeroff. Mr. Lashman, we're going to hold you off.
All right, Mr. Hearings Officer, you are asking for testimony in opposition?
If there's somebody on that unlikely group that's neutral,
I have one member of the public in the room I just think I should check with before we jump into the list of participants in Zoom. Are you interested in participating? Nope, he is shaking his head no. So I'm seeing on our list a name, the name is Stout. That's the first on the list. Thank you. We're elevating you to panelist. All right, and please remember to state your name and address for the record. You're currently muted.
Hello.
I hear you, but I don't see you. You may want it that way. It's up to you.
Oh, well, long as you can hear me, that's the most important part.
I can. Sir, would you give me your first and last name, please?
Video. Yeah, go ahead. We're going to try to give you a video here.
Oh,
Excellent.
there you are.
Hi, my name is Douglas Stout. I'm speaking representing my wife and daughter, Catherine and Stephanie. My address is 66245 Bar Road, Bend, Oregon, 97703. I'm also
Okay.
speaking and representing the Bend chapter of the Oregon Hunters Association, address P.O. Box 6618, Bend, Oregon 97708, and also for the Klein Buttes Recreation Association, address 66245, Bar Road, Bend, Oregon 97703.
Well, you're on top of it, sir.
Thank you. I'd like the following statements to apply to both appeals, please.
Thank you.
In short, we don't believe in reviewing the applicant's documentation and statements. We do not, the group previously mentioned, do not believe they have met the burden of proof on water usage and especially mitigation. It does not appear even close, even remotely have they satisfied the burden of proof. And therefore, they cannot meet conditions 10 and 38, simply cannot. At this time, we would like to state that we're adamantly opposed to this project due to the previously mentioned reasons. And I would like to ask you, Mr. Hearing Officer, to please consider the wildlife, the fish and wildlife that are at stake here in your decision. Thank you very much.
Thank you, sir. Appreciate your testimony.
Next on our list is Carol Macbeth. Can you elevate her?
Hi,
Hi, Miss Macbeth. How are you?
good evening. How are you?
Fine.
My name is Carol Macbeth, and I'm a staff attorney at Central Oregon Land Watch, where our address is 2843 Northwest Lolo Drive in Bend, Oregon. We're opposed to the application. We urge you to deny it. When you're mentioning that you had heard some of these arguments before, I wanted to point out that in our written testimony this evening, we took a new approach. We have not yet commented on condition 10 in the other proceedings, but I went through it in our testimony here fairly briefly, but I looked at it from looking at the text under the PGE gain structure, just like what does condition 10 say? And that might be a way to look at it with fresh eyes and see perhaps what we're saying that as opponents, that condition 10 is requiring documentation, updated documentation for the state water right permit, where documentation means provision of documents in substantiation, and substantiation means proof. So condition 10 is asking for the provision of documents in proof. And when the hearings officer might ask himself, do you have any documents in proof that there's water available now? Well, Mr. Kleiman and Mr. Anuda were remarking that, the taps won't turn on, can't be turned on. That's one thing, but actually if construction were to begin, and if, heaven forbid, a wildfire should go through, there would be no water to put out those fires. People's lives are at stake. Property is at stake. There's no water can be turned on legally on the property. There is no documentation before you in substantiation of or proof that there is water. There's a lot of documentation that there is no water. What you're getting from the applicant is a bunch of hot air and bluster about how the dog ate their homework and it's Miss Gould's fault. And if she hadn't protested, then something, but whatever. What they don't have is a water right that somebody could turn on the water for the construction or for anything else. They don't have one. So condition 10 is not met. There are no documents before you that show you that this water can be turned on. And now's the time. Now is the time where the water must be there. And as we also put in, I mean, they're free to reapply. So if they don't have the water right now, but later when the dog has not eaten their homework, they get some water from somewhere, great, then they can come in. Then that you can find that they apply with condition 10 and they can move forward. But while they don't have any, there's no documentation, no proof before you. We don't see any alternative but for you to deny, because to approve is in violation of condition 10 as we see it. And then we have argued before you and in other cases. You probably recall about lots of record, but I would like to point out from a slightly different angle, literally an angle, that as you see me on the screen, I'm in a rectangular shape, right? So this tax lot 7,800, we could think of it as a rectangle, the full rectangle in the past. But last summer, they took a corner out of the bottom of it. They took out 0.5 acres. So the parcel that's a rectangle is in the past, but the parcel now, as it was created last summer, has a part missing from the bottom. It has a 0.5 acre difference. It's a different parcel. It's not the same parcel. And a lot of record is a tag that you tie onto a parcel. A parcel is an area of land, and it is or is not a lot of record. So the whole rectangle in the past had that label on it. It says, I'm a lot of record. It had been verified as a lot of record. But now a small part has been taken out of the bottom. It's a new parcel, and that has not gone through this verification process. No one has said, is this a new parcel with the bottom missing, the bottom corner missing? Is it a lot of record? And when they do, it wouldn't qualify because it was created by a deed in 2021. That's not a lawful way. So I just wanted to point that out. If you think about rectangle and then a rectangle with 0.5 acres missing from the bottom, that's why the staff analysis is incorrect, because they're acting as though the lot of recordness of something persists. It does not. It's a tag on a parcel. It's specific to the parcel for which it was, asked, the question was asked, is this a lot of record? And it doesn't have any existence aside from the parcel to which it's been assigned. So this particular parcel that lacks a corner, whether or not they later put it back, in the space-time continuum, in July, the corner was taken out. And in August, the corner was put back in, but the parcel is never going to be that entire parcel that it was. It can't be, it's not a matter of being reconstituted. This parcel was formed when the corner was put back in that was taken out. And those exercises last summer, those deeds conveying the 0.5 acres back and forth, those were unlawful actions. They were not partitions, they were not subdivisions, they were unlawful creations of parcels by deed. So I think I could go into, I'm starting to repeat myself if I went on. So I'll just direct you to our written comments, which I hope we did submit different, they're slightly different. We submitted different comments for each one. And I hope my oral comments can be counted towards both. Thank you for listening.
Thank you, Ms. Macbeth. And I'm not trying to beat the poor horse to death, but it's the same comment that I had with Mr. Kleinman. And you may have addressed it in your written comments, so I'm not trying to assume something that I haven't seen and read. You are fully aware that I made a decision about a month ago, roughly a month ago, dealing with the lot of record issue and the taking out and creating the whole 9 yards. I'm not asking to be wrong, nor am I asking to be right. What I'm asking all parties, particularly the professionals involved, like yourself, that if in fact you believe my earlier decision is wrong, and you don't have to argue it now, the record's going to remain open, and I'm trying to give you an invitation to respond. But if I was wrong in my decision last month, I need you to direct me to or clarify what in particular points that I made that you believe were legally insufficient or I had incorrect facts. If I did something that you believe is wrong, this is the time and the place to address that. So that's all I'm saying. Okay?
Thank you. Mm-hmm.
All right. Who's next?
Mr. Hearings
Thank you,
Officer,
Mr.
we
Beck.
have Carolyn Wise, and I just want to take a moment to remind others on the list, if you're interested in participating, please raise your hand, even if you've sent staff an email. I see a few names that I'd received emails from. Want to make sure that you raise your hand as well. All right. I see Carolyn Wise. There we go. Oh, you're on mute.
Am I on now? Can
I
you hear
see
me?
and hear you.
Hi,
Hi.
I was here last time. I did write some email in about my experience, but I just wanted to speak to you personally. I sometimes feel like you're not hearing us, and so we do have to keep repeating ourselves. And I honestly feel like you've already made this decision in your mind. And I'm sorry if I'm not judging you correctly, but God, this is a beautiful area. There's so many the wildlife is incredible. I've heard stories about fish being caught that are full of worms because the water is too warm. There's eagles that are nesting out where they're going to put Thornburgh Resort. Those are going to go. I mean, this is bad for wildlife. I just love this area, and I love the people and the farmers. And there's some beautiful farmers out here. They're going to lose their farms, and they already are. The wells are drying up. So I don't know what it is that we need to do to ask you. Can you please look into your heart and say, God, I love Oregon. I love this area. Can we keep it? Does it have to become a resort? Even if it were, where are the earth-friendly structures? So where are the water-saving techniques? There's so much out there that it could be. So that's my request is can you open your heart a little bit more maybe? Thank you. That's it. Bye.
Thank you, Ms. Wise. I appreciate your sincerity and I appreciate your testimony. Thank you.
Thank you.
Jim Gill?
Yeah.
Hello, my name is Nunzi Gould. Can you hear me?
Yes, and I can see you as well. Thank you, Ms. Gould.
Perfect. I'm at 19845 J.W. Brown Road. My comments relate to both the site plan and the tentative. And I appreciate simplicity brought at today's hearing of a complex issue related to water. And the issue, hearings officer and staff planner, has been something that was raised since the inception of Thornburgh Resort in 2005. So this issue is not a new issue. It was raised very determinedly in 2008 when the fancy new hearings room was established there at the Boynes and Sawyer meeting room, and the connection with the Wild and Scenic River and the State Scenic River, which is where Deep Canyon Creek confluences with the Deschutes River. It would confluence more fully if it had its water rights, and it would confluence more fully if both ponds that are in Deep Canyon Creek that are part of the Fish and Wildlife Plan to be removed were actually removed. And those have not occurred. My interest in testifying today this resort really lacked the proving specificity since early years, many years. And in these site plans and tentative plans, you will see yet more requests for less parking, less building occupancy, and even more water thirsty applications. And I don't believe that if you build multiple meeting and event rooms that you should be given any grace on shared parking. The whole point is to have them used and booked and to have people arrive for the events, the golf club, the welcome center, the community hall, and not share parking. So I really would encourage the staff to be thinking about a successful resort, if it actually can happen, that it have all the parking that it needs. And as we know, this place is in the middle of no transit, no shared bus system, no pedestrian or bicycle routes. This is in rural Deschutes County. It is many miles from the city of Bend, from the city of Sisters, and also from the city of Redmond. So the notion that people would not be arriving by a vehicle is fictitious. And we need to be sure that parking meets the ADA requirements. So it was of particular interest that I saw this in the staff report, photographs from a foreign country, license plates on vehicles from a foreign country parked on this new grass paver system that staff and the applicant are proposing for this development. And while I get that the photographs are all beautiful color green, green is not what is native to the Thornburgh Resort. The Thornburgh Resort, at best, has native bunch grass. It does not have lawn. It does not look green. Anything that becomes greened is using water. And right now, there isn't water in this development to be making anything green. So I keep wondering, so what is it exactly that they want to use these green paving devices or failed plastic parking products that the county has not been able to use on their own roadways in rural Tumalo? And I'm thinking that the reason they're trying to do this is so they don't have to show the stormwater swales in their site plans. That's the runoff from your parking lot. That's the runoff from your asphalt. Those are very important things on a site plan and a tentative plan. And it isn't because they're trying to preserve native vegetation. That isn't the reason. They do not want to be beholden to the full amount of parking that each of these golf club welcomes house, all of these facilities would actually require were they fully used. So we need to have parking that works for the ADA. That's not this green concrete stuff that requires water. We need to have an asphalt parking where you can snow remove in the wintertime that meets ADA and have the appropriate stormwater swales in these site plans today. So I really would encourage staff to be reviewing the numbers of parking and also to be considering if the Phase A1 road that goes over Klein Buttes and attaches through the state of Oregon land tax lot 5300 in Township 15, Range 12, which connects the South Resort to the North Resort, tax lot 5000. If that road is not actually constructed to meet the fire department slopes, and if that road is not constructed to meet emergency evacuation needs, then we need to be reviewing where all the traffic gets placed. So originally in the CMP and the FMP, transportation was modeled to be using Highway 126. That's the road that goes from Sisters to Redmond. The roadways that you have now, which actually don't show that the road for the gatehouse, the clubhouse, the welcome center would need to be built for this project, that ties into Klein Falls Road, that road would need to be built, and the emergency evacuation for all of these homes and overnight units, the lodging, the guest quarters, you would need an emergency evacuation to get you up and over the ridge line. So at the very least, we need to have a safe development that is planned, that works in the event of a wildfire. You don't need to have big evergreen trees for a wildfire in the West. We've seen what happened just recently in Denver with the brush fire. This is real. These are important steps. And having the fire hydrant capacity and the fire department access is of critical importance to the public who may be visiting at this location, as well as residents, as well as visitors. So the primary entrance for the resort in Phase A attaches to Eagle Road, which attaches to Highway 126. The secondary access is the roadway that gets you to the gatehouse at Klein Falls Road. But if they are now relying just on the construction road, on the dirt construction road through a right-of-way to be providing all this emergency access, then certainly they need to be identifying that with the BLM right-of-way and having that appropriately managed. So I think I'll leave my comments to that. The public safety aspect of this development should be a very important component. And having fire hydrants designed or shown on a map that don't have water in them is not in the public interest. Thank you.
Thank you, ma'am. I appreciate your testimony.
Ruby Swanson? Thank you.
Am I there?
I hear you. I do not see you.
Okay. It wouldn't be a surprise. I'm kind of new at this. I'll be brief. There's many residents in Bend I'm supporting.
Would you give me your full name and your address, please?
Yeah, I'm sorry. My name is Ruby Swanson, 60451 Umatilla Circle. That's in Bend, 02. And I'm in opposition of this resort that's going in, mainly based on the fact that we are in a drought and it's not going to get any better. And we have climate change going on that's crazy. I think it's foolhardy, just a foolish waste of time and money to be doing this. It's pretty simple to me. I haven't seen anything in my eyes I've lived in Bend since 1990. And I'm just really surprised about all the irresponsible planning and development in Bend. And it's not just me. I'm speaking for many people. And I feel like I've got to say something because it's just very irresponsible with water, land use, and everything. Wildlife, fish. I'm a whitewater rafter, so I understand whitewater and rivers and everything. So it just seems so wasteful. It doesn't conserve energy. I mean, Yeah, I mean, I don't know. I just don't agree with that. And that's, I think, basically, I think we need to be responsible adults and figure this out because this is not seeming to go in a responsible way. And that's all I have to say.
Thank you, Ms. Swanson. I appreciate your
Thank you.
testimony.
I appreciate you listening to me.
The next participant is the letters CFF.
Yes, hello. Sorry for the delay. Can you hear me?
I can hear you. I cannot see you.
Okay. Let's see my.
It's up to you.
Go ahead. Yeah, I'm going to go ahead and just speak to you.
Name and your address, please.
Yeah, hello. My name is Kate Cassad. I represent Cassad Family Farms.
Could you do me a favor?
We're based in.
Could you spell your first and last name? Because I can misspell probably both of them.
Yeah, CATE. Last name is CASAD.
Thank you. And your address?
2595 Northwest Elm Lane. We are based in Madras, Oregon.
Go ahead, ma'am.
Hi, thank you, Mr. Hearings Officer. I actually wanted to reference, I've spoken in opposition to Thornburgh before. I represent our farm. We have farmed for 10 years in Central Oregon, and we used to farm east of Bend. We've grown organic food for thousands of families and most of the major restaurants that you eat at in Central Oregon. In 2017, we moved our farm to Madras because the opportunity to grow more food was expanding, and we couldn't find contingent farmland in the Bend area. So we moved to Madras in order to grow more food. In moving to Madras, we went from being senior water rights holders to being junior water rights holders. And we've, seen the effect of the drought very significantly. This year in 2021, while we paid for 100% of our water rights, we only received 30%. And the way that those work is you pay for 100% even though you're only delivered 30. We fallowed, dried up 70% of our farmland. So it was a significant shift. There's a lot of ecological impacts as well as economic impacts on all of the junior water rights holders here in Jefferson County. Jefferson County is the biggest, it's actually the second biggest irrigation district in all of Oregon, and we are one of the highest grossing farming districts in all of Oregon. And what we are seeing regionally, we are all tied to the same water ecosystem. This basin has for a long time lived very segregated. This district over here, this district over here. We are all sitting on the same shared aquifers. We are all reliant on the same snowpack, and we are all reliant on this being either a livable ecosystem or a non-livable ecosystem, us and the wildlife. As the drought has persisted, we're watching both inflow stream as well as groundwater is not at all what we thought it was. For example, with all of the top water people working on figuring out how to allocate irrigation resources in 2021, even their worst case scenario planning of how much water we should have for the season wasn't even close. So what we see is that even the experts have been wrong about how much water is available in this region. And we're learning that lesson, and we need to be humble and ask ourselves, are we really reconsidering, is this resource still here? Things are changing quickly from a water perspective in this region. And so there's one other point I just wanted to mention. Deschutes County has a comprehensive plan in which it states the following goals and policies. Goal 1 is to preserve and maintain agricultural lands and the agricultural industry. I won't go into reading the policies that are listed below that, but it is not actually contingent with the county's comprehensive plan to preserve and maintain agricultural lands and the agricultural industry, when the very proposal of this development further threatens the single resource you need to be an agriculturalist in the desert is water. I think that I, like you, cannot become an engineer overnight, but I'm listening to so many experts from the farming perspective to the wildlife perspective. They all agree, including the most recent Oregon Department of Fish and Wildlife statement as of November of 2021. They seriously call into question whether or not there is actually anywhere near the amount of mitigation water that they would need to meet the conditions of approval. So thank you for listening. It's an honor to be a farmer in Central Oregon. It's an honor to grow food for this region. I sincerely hope that you, Mr. Hearings Officer, and the Deschutes County planners really understand what's at stake for the agricultural community here in Central Oregon, and over-allocation of a resource that is not there, mitigation water that is not there. You don't just threaten the wildlife, you threaten the very livelihoods of farmers and ranchers in Central Oregon. Thank you for caring for us as much as we care for you.
Thank you, Ms. Casada. I appreciate what you do for a living and your services, and I appreciate your testimony. Thank you. Ms. Brewer?
I don't see any other hands raised, but I did receive an email from Paul Lipscomb intending to testify this evening. I hate to put you on the spot, Mr. Lipscomb, but if you are interested, please raise your hand and we'll elevate you. And I usually receive a request from David Arnold, whose name I also see, and your hand is not up. So I just put you both on the spot. If you are interested, please raise your hand and we will elevate you. I see David's hand has just gone up. We'll elevate you over. Thank you. And so did Paul. That's great. And Mr. Arnold, I see you're here, but you're still on mute. I think we're ready for you. Can't hear you. If you're participating by phone, you may need to dial *6. It doesn't look like you're by phone, but just in case. Oh, we can see you, but we cannot hear you. Sorry, we still can't hear you. If it's all right, we can skip to Paul Lipscomb and come back to you. Yeah? Okay. Thank you. I see Senior Judge Paul Lipscomb is on his way over. Processing. There we go. Mr.
Hello, this is Paul Lipscomb.
Your Honor, I can hear you, but I can't see you.
That's probably just as well.
Well, I don't think so.
I'm getting ready for a medical procedure tomorrow, and so that's the reason I changed my mind about speaking. But I also wanted to say that I heard and understood what you said about written comments, and I hope that you'll read the comments that I submitted of the legal nature as to the change in circumstances by the urban growth boundary of Bend, now including more than 100,000 people by every measure. And that's really my point here. And I'm not going to belabor it because it's very well covered in my brief. So thank you for the opportunity, and good luck with your decision.
And Judge Lipson, just to make sure, I don't know if you gave us your address. That's one. And let me interrupt one more time. I just want you to be aware that I did receive or did print off and review a copy of your December 8th, 2021 memorandum. So I have, in fact, reviewed it. As I'm sure you would say from the bench, I have not made a decision based on that document alone, but I have, in fact, reviewed it.
Thank you.
And your address, please?
P.O. Box 579, Sisters, Oregon.
Thank you, sir. Good luck in your procedure. Mr. Arnold available?
Can you hear me now?
I can even see you.
Holy cow. Well, I too just returned from a surgical procedure today, so you'll have to forgive my uncombed hair. My comments were due to the water, and I believe that Nunzi Gould's attorneys presented the case that I would have talked about. So I just support their conversation with you on the issues with water and the drought that we're here in Central Oregon. So once again, and my name is David Arnold, 19830 Canarn Road, Bend, Oregon, 97703.
I thank you for your testimony, sir. I wish you best in your recovery.
All right, Mr. Hearings Officer, I do not see any other hands raised.
All right. As I indicated in my opening comments, Ms. Brewer, if you'd like to take this opportunity to give any comments, you may. I know that the normal procedure is to have you go last, and I will give you another opportunity if both or if the applicant's comments or rebuttal trigger something you want to say. So I'm not trying to exclude you from saying whatever it is you want to say.
I appreciate that very much. I don't have anything to add, and neither does Will Groves, who's seated behind me.
All right, thank you. Mr. Katsaroff.
He's on his way.
Back. Again, for the record, Ken Katsaroff, 1420 Fifth Avenue, Suite 3400 for the applicant, Seattle, Washington, 98101. If you could also please elevate Mr. Delashmitt and Janet Newman. I believe they will both be making remarks following mine. I want to hit a couple of quick things on rebuttal. I want to I'll start with comments from Mr. Kleinman. He claims that we're trying to brush aside the requirements of Condition 10 and Condition 38, and that's just simply not the case. Ms. Newman will address water issues with particularity, as well as significantly in a filing today, as well as in our post-hearing comment. As I remember, Mr. Kleinman asked the record to be left open. And so we'll hit it there. I want to make one quick clarification in terms of the history of the conditions. Mr. Kleinman seems to continue to believe that Condition 38 mitigation is the same or somehow connected to Condition 10. That is simply not the case, as has been ruled by LUBA and the Court of Appeals in two affirmances, LUBA decisions. So they keep arguing this point, and it's simply not accurate. I think one point of illustrative history would be the fact that Condition 10 comes directly from the CMP and the CMP decision, whereas condition 38 didn't even happen until the FMP approval. So they can't be directly tied together. It simply doesn't work that way when it comes to the procedural posture of this entire case. They continue to argue that we don't have water. Again, we are going to address that. Ms. Newman will, and in later filings. I want to be clear with regards to Mr. Lambie. There's a lot of discussion about dropping wells, in theory anyway, as well as flow standards. And that, I'm sorry to say, is almost irrelevant. In this case, it has been determined, which is the only measure we have under the law, that it's the water rights themselves that matter. There is no minimum flow requirement contained in any of the approval documents or the conditions. So that's an important point to say here. This is about water rights certificates. And I'm going to use the word that seems to be a dirty word for Mr. Nuda, which is that would be a collateral attack. And the only reason that matters and that posture matters about a collateral attack is issues that were conclusively decided, like this issue in the FMP, it would be a collateral attack to determine otherwise. It's not a collateral attack when it comes to a specific decision that's new or a new issue or something that wasn't addressed by the FMP, but something like a water rights certificate versus flow is in fact something that was decided before and can't be collaterally attacked at this time. Mr. Lambie as well as Mr. Nuda seem to believe that there is some sort of agreement with Oregon Department of Fish and Wildlife. Mr. Kleiman said the same. That is simply not the case. There is no agreement with ODF&W, and there is no requirement for us to have an agreement with ODF&W. So I just want to be clear here. There isn't an interest of ODF&W that Thornburgh is required to meet. And if they can show us some sort of agreement, we'd happily address it, but there isn't one. One last thing. Mr. Anuda seems to believe that I'm not quite sure, that Big Falls Ranch might be still pumping water that Thornburgh controls. I'm not quite sure how that would occur. And if they were doing so, that would be an issue for Big Falls Ranch and the water master to determine, not for Thornburgh. It's our water now, and Big Falls Ranch cannot legally pump it. So I'll leave that there. One last point I would make. There seems to be a new narrative forming about this is the last stop. Well, we've heard that in a couple of proceedings now, and that for some reason the site plan is the time that must happen. But as I think all of at least the folks that do quite a bit of these land use hearings or land use procedures know, even if it is a building permit stage or a plat stage, for example, that's not going to get sign off unless all the infrastructure is actually there, and that includes water. And so I point that out in that will have to occur again later. So we have the water, we can prove that we have the water, and even if there was a question, a land use approval, a site plan, and a plat won't get final approval unless and until that infrastructure exists. So this is not the last stage, as they argue every time. So I just throw that out there as well. With that, I would love it if Ms. Newman would like to speak with particularity on water, although I would be happy to answer any questions that the hearings officer has of me.
I do before Ms. Newman, and I think it actually relates to potentially what might occur during her testimony, is that, and it's the point that you made last, and it's the last stop comment. Okay.
Yep.
So I know how I've ruled with respect to condition 10 and 38 in prior decisions.
Mm-hmm.
And I'm sure you noted, probably twitching a bit, my comments to Mr. Kleinman regarding if I'm wrong, point out where I'm wrong, show me where I'm wrong in those earlier decisions. And that may not have been a welcome comment on your part, but that's the part that you get to live with. What does I think I put him on the spot as well as Miss Macbeth, and saying, look, I mean, show me what is really different than these prior arguments. And the one thing that I'm going to put you on the spot, and perhaps Miss Newman, is I think relates to this last stop issue, is that if in fact, in a hypothetical sense, that Thornburgh didn't have the ability to turn on the tap, using the language, who does what and how? In other words, what stops? Because you have to understand, in my position, I am concerned about everyone who testified here. They all have an equal right, including you. But I also am concerned that any decision that I make places the county in a position that they have to exercise an action or something similar to that, and simply say, we've got to bring a lawsuit, we've got to bring an injunction, we've got to initiate a code enforcement proceeding, and I'm not knocking the county's code enforcement process, but for almost 19 years, I was the chief code enforcement hearings officer for the city of Portland. And I will tell you quite candidly that the code enforcement process is fraught with problems that force it to be fairly ineffective in a lot of cases. So I am actually concerned about the last stop comment. And it seems to me incumbent upon the applicant to give me better information about how logistically is that dealt with, if it's not dealt with in this proceeding. Keeping in mind that I've already made rulings in a couple prior cases that potentially could put me at odds if, in fact, I said, this is the last stop, therefore, let's re-investigate, let's reconsider the entire water issue.
Okay. All right. I'll make 2 points, and then if Jan wants to jump in, great. So the first point I would make is in our last briefing in the last case, which is included in this record now. I submitted it. There's an entire section about enforcement by Oregon Water Resources Department, and I'll note that OWRD has plenary authority when it comes to water, including the water master having the ability to actually arrest an illegal water user. So should we turn on the tap, so to speak, and the department all of a sudden changes its mind that we have a valid water right, then they can literally arrest our principal, shut off the water, civil and criminal penalties. So this is not incumbent upon the county at all. It's incumbent upon the Oregon Water Resources Department that is the arbiter of water rights. So I'll leave that there. And then the second point just went out of my head. And so if it comes back, I will let you know, or I'll put it in writing.
Ms. Newman, you're up.
Thank you. Can you hear me, Your Honor?
I can.
Okay.
Identify yourself.
Yes, I'm Janet Newman, the water rights attorney for the applicant. I'm at the Tonkin Tort Firm, Tonkon, TORP, 888 Southwest 5th Avenue in Suite 1600, Portland, 97204. I submitted, well, first of all, my testimony goes to both files here tonight.
Thank you.
And I did submit written comments today, so I will only hit the high points and you will see those. And I will note that the letter that I did submit today addressed several of the issues that Mr. Anuta and Mr. Lambie and Mr. Kleinman raised tonight. And it's not because we're psychic, it's because those issues have come up every single time. So it was not difficult to anticipate what their arguments might be. And by the same token, those arguments have also been addressed in our previous submissions, including the final argument on the last round of appeals that you made your decisions on. And as appropriate in the open records period, we will come back and sort of identify specific points so that you can refer back to them and see where we address those things. I just want to mention a couple of things. The issue of timing, and this goes to your question just now to Mr. Katsaroff as well. There are conditions on the land in the land use process. The county does not have control over the water. It doesn't have jurisdiction over water rights or water decisions. So it is appropriately conditioned, the final master plan and other county approvals on documentation and information from the applicant that they have what they need. This is not, for the reasons that Mr. Katsaroff just described, this is not the last stop. I mean, the last stop in terms of water is the Water Resources Department. However, in terms of the information requirement and documentation requirement of Condition 10, we have argued and demonstrated numerous times throughout these land use processes that currently the applicant has an existing valid water rights permit for the full water needs of the Thornburgh project. It is not expired because water rights don't expire as of their own terms. Before the expiration date, the applicant submitted an extension application, and that was ultimately, that extension application has been approved in a proposed final order by the Water Resource Department that Ms. Gold has contested. We don't, argue with any of that. Until that contested case is resolved, and Ms. Gold would like you to believe it's going to be resolved in her favor, and Mr. Anuta as well. But at this point, the applicant has an existing water rights permit that's been in place since for many years with a priority date of 2005. And unless the department cancels that permit after a contested case hearing on Ms. Gold's protest of the extension, that permit will remain. The opponents try to say that the applicant must know that that permit is going to go away because they've made lots of other applications. That's simply prudent, given the fact that Mr. Kleinman has stated on the record that Ms. Gold is planning to protest every request of the Water Resource Department that the applicant makes. It makes sense not to put all your eggs in one basket, and so that's the situation as it is today. But as far as meeting Condition 10, we are in compliance with what is required at this point in time. The opponents also want to suggest that all of the things that are ultimately required by the Fish and Wildlife Management Plan should have happened by now, and that is just not what the plan says. There's all of the things that need to happen in terms of ultimate transfer of the Big Falls water right to an in-stream water right, the complete removal of the impoundments in Big Falls, in Deep Canyon Creek. They've been partially removed, but the complete removal, the provision of all the mitigation water, the abandonment of 3 of the wells that Mr. Anuta talked about, all of those things are not set to take place until the water system is built and in place and ready to go. And the applicant already does have the amount of mitigation in the record and provided that's required for the stage of development that he is at right now. So, and another thing that Mr. Anuta stressed today was the fact that until was his opinion that until the Deep Canyon water right or the Big Falls water rights are protected in stream in an in-stream water right, somebody else is going to, all kinds of other people can take that water. This is addressed in the letter that I submitted today because we anticipated that they would make this argument again. And there's only one water right holder between Big Falls Ranch and Lake Billy Chinook. That is a segment of the river where flows are gaining in the river because of discharge from groundwater. And the one other water right is for 3 cubic feet per second. So all of this panic about other water users who are going to be able to take the Big Falls water right, that's not being used right now, that's just not true. And that's explained in the letter I submitted today. The other thing that we have addressed numerous times is the point that the Big Falls Ranch water rights are not being diverted from Deep Canyon Creek right now. I mean, and Mr. Lambie's, theoretical argument about what's going to happen when certain wells draw down to certain elevations and springs are, the hydraulic head, all of his technical explanations. We've dealt with those in previous submissions. We'll deal with them again during the open record period. But basically, the fact of the matter is there is water flowing in Deep Canyon Creek. We've had photographs of it in previous submissions, and the 5.5 CFS that Big Falls Ranch was diverting from the creek as surface water flow previously. They are no longer doing that. They are diverting some water from the groundwater for their other water rights and for a portion of the transfer of the Deep Canyon Creek surface water rights. But the portion that has been conveyed to the applicant, to Central Land and Cattle, is not being used either by Central Land and Cattle at this moment or by Big Falls Ranch. So that is the water that is flowing in Deep Canyon Creek, even though that mitigation is not yet technically, legally, or physically required under the Fish and Wildlife Management Plan. So I will leave it at that. I know that you will read the comments I submitted today, and we will address some of these other issues in the open record period. But in conclusion, I'll just say that nothing that we heard tonight about the water issues are new issues. They've all been, these arguments have all been made before, and we've addressed them all before, and we'll point out how we've addressed them the next time around.
Thank you, Mr. Newman. Have no questions.
Thank you.
Mr. Delaschmidt?
Good evening, sir. Cameron Delaschmidt for the applicant. My address is 2447 Northwest Canyon, Redmond, Oregon. Thank you very much for allowing me to testify. A couple of things. Ms. Newman mentioned the extension. The proposed final order was issued and then contested. A clarification there, the final order was actually issued and then Ms. Gould filed suit both at the Court of Appeals and and at Marion County Circuit Court, and Water Resources withdrew the the final order allowing it to go to a contested case, which was the purpose of Ms. Gould's suit. But the final order was issued, it was approved, and that was issued. Another thing, the Big Falls Ranch water that we have purchased, that water is no longer being pumped from Deep Canyon Creek or from the either of the 4 wells that Mr. Lambie mentioned. It is allowed to flow into the river, whether you say it's coming from Deep Canyon Creek or from groundwater. It is going into the river today. And as Ms. Newman said, there is only one user below Big Falls Ranch that could possibly take it, and the flows are so dramatically substantial that that would never happen, that that would occur. Ms. Gould spoke about the right-of-way and the northern access, mentioning that the northern access was the primary access. I'm not quite sure which roads were secondary, but it was clear that she believed that that was the primary access. The tentative plan for Phase A1 and the tentative plan for Phase A2 show that road that she was referring to. In both of those tentative plan applications, documentation was submitted with approval from the Redmond Fire Department, allowing the grade that we were proposing in those roads going across to connect those two. So that has already been approved as part of both of the tentative plans, and it wasn't an issue on appeal. Further, there's concern and question about life and safety and having it at an acceptable level. That was covered extensively with the Redmond Fire Department, that our grades going over that steep area were acceptable to them. And also International Fire Code and the Redmond Fire Department have requirements for the secondary access at particular times. They have very detailed requirements for how far those secondary access points need to be from your primary access in relation to the area that is being covered or being developed. And as we continue forward with all of our planning and all of our any structures that we put in, those will fall under those requirements with Redmond Fire. Mr. Nutter talks about abandoning wells. That was a fairly big thing with him. The well that is in the application that he refers to, that we were going to use construction water, those wells under the FWMP were required to be abandoned at the time, as Ms. Newman said, when the domestic water system was in place and operational. That has not occurred yet, and it was not anticipated that that would occur during the period that we were saying that we would use construction water. And Ms. Gould has spoken about the need for asphalt parking. And when we say that we would have used pavers for overflow parking, she would prefer, I think, that we have asphalt parking. In everything that we're doing on site, we're trying to do it where we have lower impacts, not greater impacts. The more asphalt you have, the more water you're diverting and capturing in stormwater issues. And if we can use something that's permeable paving product, it reduces the amount of impact, both aesthetically and functionally from a stormwater runoff standpoint. So in any area that we can use a alternate permeable product, we're going to try to use it so that we have lower impacts on use. And I think that that's all of my comments. I appreciate the time. Do you have any questions for me?
No, sir. I appreciate your testimony.
Thank you.
Mr. Katzeroff.
I have one more comment because it reminded me when Jan was speaking, and that's Mr. Kleiman asked kind of what is this documentation that we need to provide to prove compliance with condition 10. And this was hit squarely on the head by Luba. And pardon me, my dog is wrestling with himself in the background, if you can hear that. But basically, and I'll resubmit this to the record, but Luba determined that there was no deference required to the county's interpretation of condition 10, and instead did it under a legally correct standard, reviewed it for legal error under ORS 197-835-9 sub A sub D. In any event, what they determined is that we conclude that the county did, this is the quote, sorry, we conclude that the county did not err in finding that condition 10 is satisfied by documentation that permit G17036 is not canceled, and an accounting of the mitigation water needed, end quote. So applicant has again provided that same documentation that was reviewed for legal error previously, and so logic would say that the same decision, the same finding would also be proper in this case. So I just wanted to read that because it speaks directly to the appellant's question of which documentation, and Lib has already ruled on that. So with that, I don't have anything else to add, and I very much appreciate your time.
Thank you. Anything else from staff?
Just if you wouldn't mind, sir, confirming that the applicant is in agreement with the post-hearing period before we leave tonight?
Mr. Katsaroff?
7, 7, and 7 sounds fine with us. Thank you.
Thank you.
Oh, I do have one question, though. I'm sorry. Do we have any change in procedure based upon one email is fine as long as we reference both records? Is that what I understood in terms of filing written comments?
That's acceptable to me, and let me just confirm that with Ms. Brewer.
Yes, that's acceptable.
Okay.
Thank you.
All right. Mr. Kleinman, I'm not trying to ignore you, but I don't legally have to give you a final word. I'm going to assume unless you're adamant that you'll provide me with whatever comments you have regarding all the applicant rebuttal in your during the open record period. So unless you raise your hand and shake it, I guess I'm going to move on to the dates and times.
I did not.
Okay, thank you. All right, so the record will remain open. It will remain open until 5 o'clock on January 11th, 2022 for new evidence.
Just want to point out that the office hours for the county have changed. It's now 4 o'clock. We've recently codified that change, so just make sure that's clear.
Okay, I'll have you reiterate that during the logistics part.
Thank you.
Sure, no problem. So the 11th will be the deadline for new evidence, the 18th for rebuttal evidence, or responsive evidence, I like better, and the 25th for applicants' rebuttal or final argument. Those dates acceptable to you, Mr. Katsaroff?
Oh, we'll have to elevate him. Yeah. Okay. We're bringing him over again. There we go.
Yes, sir.
Okay.
They're acceptable.
Mr. Kleiman, any objections to those dates?
Bring him over. All right.
No objection.
Thank you. All right, let me just give a very brief description for those of you who are not familiar with the process. until 4 o'clock, which I'll have Ms. Brewer reiterate. But apparently at 4 o'clock on January 11th, anyone, whether they're here testifying today or not, anyone may submit into the record evidence that they wish me to consider in making my decision. Anyone. By 4 o'clock on the 18th, there will be the availability to submit into the record evidence in response to whatever was submitted during that first week, or by the 11th. Anyone may do that. At 4 o'clock on the 25th, the applicant, and only the applicant, may submit a final argument. I've been through this before with Mr. Katzeroff, so I believe he understands that final argument means, as it does in the statute, that there is no new evidence. And I prefer not to be strict on that, but if I see new evidence, I tend not to consider anything in the final argument document. So 4 o'clock on the 11th, new evidence. 4 o'clock on the 18th for responsive evidence, and 4 o'clock on the 25th, applicant only, final argument. All right, Ms. Brewer, would you please inform those who are still with us how they get information into the record? I'm going to reiterate that if you wish the evidence to be in both files, in fact, I'm just going to let Ms. Brewer, in fact, I want to talk to Ms. Brewer real quick.
One-on-one, sir?
Yeah, how about that? I just want to make sure, is it staff's preference that 2 documents, if in fact the same information is going to relate to both files, does staff prefer that it be submitted twice?
No, actually, because I've received a number of emails already that don't have any number reference on them at all, they're just generally diverted to these topics. It's been more simple to get one copy and then create 2 copies for each record, so that on our Acela database, it's basically a copy and paste exercise from one complete record to the other. So it's almost easier if we get it one time, as long as it's clear. As long as it's clear that they want it on both. If it's not clear, we're being extraordinarily cautious and including it on both, an abundance of caution.
Thank you. My request then to anyone submitting evidence into the record during the open record period is that you indicate whether or not you want it in one file or both files. I would prefer that, but taking into consideration Ms. Brewer's last comment, just get it submitted. But please reference case numbers, at least one of the case numbers, but preferably both of the case numbers. Ms. Brewer, you want to go through the logistics again, just to make sure that we've got...
I'll definitely do that for you. I do want to make you aware, I'll read through my notes, but I want to make you aware that there are 2 hands raised, Mr. Carl Anuda and Kate Cassad. Their hands are raised, so I'll read through this quickly, and then if you choose to call on them, we can elevate them. So for the open record period, please keep in mind that the county does not retrieve information from website links or personal cloud storage devices, and it's your responsibility to submit all evidence and testimony you want the hearings officer to consider. All submittals should be addressed to me, Angie Brewer. I'm the case planner assigned to this. My email address is, I'll spell it out, but it's on the final slide of this, and it's on all of the notices that you all have received or have access to. It's Angie, ANGIE, .brewer, BREWER, at deschutes.org. You obviously can send it to our office address to me. That would be just fine as well. Any email submittals that exceed 20 pages include color documents or include any documents that need to be printed at larger than 8.5 by 11 must also be submitted as a hard copy. And as we both mentioned a few minutes ago, we've codified a change to our office hours, so now all submittals must be received by 4 p.m. on that final day. please don't wait till the last minute so that we can make sure we get everything uploaded as quickly as possible and make it visible to everyone who's waiting for that electronic database to come online. I think that concludes our requirements for submitting comment. And again, if you'd like us to move Kate Cassad or Carl Anuta over to panelist, we can do that.
Just in an abundance of caution, we'll move them both over. I will take Ms. Cassad first. I'm concerned that she may have a question, and if she has a question regarding logistics, I want to get that resolved.
Okay.
Yes, thank you, Mr. Hearings Officer. It is sort of a question. I'm just trying to, I've been sitting here asking myself really, what is, your position as a hearings officer. I just learned very recently what a hearings officer is. And just correct me if I'm wrong, but it seems like the role of a hearings officer on behalf of the county is to be sure that the county is more or less following its own protocols and codes and rules. Is that correct?
Good question. I thought I covered it in the opening comments, but obviously there's too many opening comments and they all get bundled together, and I appreciate it. So let me briefly respond. As a hearings officer, I preside over what's called quasi-judicial hearings. Those are kind of pretty legal-ish kinds of hearings. And I make decisions, and my decisions are mandated to follow relevant laws. So that's why in these particular cases, probably more than most cases that I'm involved with as a hearings officer, we have lawyers on both sides. And those lawyers are supposed to identify for me what they believe to be the relevant laws and rules that apply to this case. And then I take whatever the evidence that comes into the record, your testimony included, I take that evidence and see whether or not it applies and how it applies to the relevant laws and rules to the case. So that's kind of the technical approach. Let me tell you the practical approach. And often in hearings, and I didn't do it this evening, but often in hearings, part of my comments when I talk about the role of a hearings officer is to say that I am limited to only those relevant laws and rules. I can't make up laws or rules. I can't exclude relevant laws or rules. And in some cases, what may seem generally right or wrong, but contrary to those relevant laws or rules, I'm forced to follow the laws and rules that apply. So I don't get to do what I want to do in a lot of cases, and I'm not implying that in this particular case.
Sure.
What I'm telling you is that I'm obligated, in order for the system to work properly, is to follow what laws or rules apply to this particular case or these two particular cases. So I'm hopeful that helped a bit.
Yeah, and it does. And I'm familiar with the process of permitting and county codes. My dad was a permit consultant. And so I actually used to work for him, and I understand the process of, submitting application to the building department, whether for building permit or land use issues. And from what I've read, and I'm happy to, I will follow up and submit this in writing, but from what I understand, please correct me if I'm wrong, that Deschutes County Code dictates that there is proof of mitigation water in order to consider an application. And when I was listening to Ms. Newman speak, sifting through a lot of words, what I heard was when, asked about where is the mitigation water, as that phrase you all were using, like this isn't the final destination, or whatever that terminology was. More or less what I was hearing her say in regards to where is the mitigation water is kind of like, we'll get to it. Like, we're not done, we'll get to it. But in order for the county to follow its own code, it can't actually review applications that don't have proof of mitigation water. Like right now, you can't really say like, oh, we'll get to it. So that was
so
just my observation.
Yeah, let me interrupt you there. And I understand where you're coming from. I would, so I don't get myself in an uncomfortable position, at least, well, I think in both of the staff decisions in the cases that we're dealing with today, it talks about, right up front, it's within the first 3, 4, 5 pages. It talks about the history of the Thornburgh Resort, and the Thornburgh Resort as a destination resort is required to go through a number of steps. And if you look at the history of this, some of the provisions that might seem to make sense in the Deschutes County Code and think that they apply across the board have already been undertaken in an earlier step. And that is, quite honestly, Mr. Kleinman's argument that we need to reconsider some of those things now. And I will look at what he has submitted and consider what he submitted in light of the entire record. But I'm asking you, just go back and take a look at the first 4 or 5 pages, I think it is. It's in the history of the Thornburgh result. So with that, then I'm going to turn to Mr. Arnuda. Thank you, ma'am.
I have a logistical question, and it's really sort of for staff because I doubt you can answer it, Mr. Hearings Officer.
That's
wondering how long it will take for staff to get the materials that the applicant submitted today uploaded to Excella, because in the past we've had some issues with it taking a week or so, and since we've only got a week to respond, I'm sure the applicant's in the same boat. They want the materials that we submitted today. And I'm wondering if Ms. Brewer can give us some idea of where they're at in their process of how long it's going to take to upload things.
Yeah, we had the same discussion during the last set of hearings relating to the overnight living units and the modification. But I'm going to have Ms. Brewer kind of reiterate the process of getting things, I call it uploaded. I don't know if it's up or down. Never sure. But we'll have her respond to that.
Well,
Thank you.
I'm happy to share that we have a new administrative professional on our team that started yesterday. We've been down in capacity for months now, and it's been a struggle for the rest of planning staff to kind of keep up on our sort of traditional uploading process. And the process is multi-stepped, and when you don't do it very often, it takes a little bit longer. And as you can appreciate, this is not the only file that we work on, and so there's a lot of information trying to be uploaded by a lot of cooks in the kitchen, so to speak, all at the same time. And so it's a bit of a process, but I'm very, very happy to share that we got some help yesterday, and she showed back up again today, which is great. And we have a lot of things on her plate to upload for these two file numbers in particular for the next 24 hours. So tomorrow you should see a whole bunch of documents uploaded. We think it'll be faster than the last month or so. Will Groves is our planning manager, and he's here. I don't know if you have anything you want to add to that. He's saying no. We're certainly doing the best that we can. It's a very busy time, an unprecedentedly busy time for development in Deschutes County, and we're understaffed. So we're cognizant of the timelines. We do try to prioritize uploading things that are at hearings and in open record periods, but it's just difficult to keep up. So progress is happening as we speak, and hopefully you'll have a better experience this time through.
Thank you.
Thank you, Ms. Brewer. Mr. Anuda, I hope that answers the question. I have nothing that I can even add because I'm not at that physical location, and I'm not uploading or downloading or side loading, whatever it is, these documents. I appreciate your position, and I wish you the best. That's all I can say.
Thank you.
All right. With that, then, anyone else hands raised?
No hands raised.
Any other hand? Is that no?
No. I did see Mr. Katzroff's for a second, but it is down.
Okay. All right. So I look forward to the receipt of documents into the open record period. The one question that wasn't asked is when my decisions will be rendered. Generally, my decisions are due to the city, the county, approximately 21 days after the record closes. And I'm not good at math, so I'll let you figure out when that is. But that's when you might be looking forward or not to receipt of the decision. I appreciate everyone who testified today. I appreciate the respect shown. Certainly, I understand at least the one person who testified saying my mind was made up. That's not the case. That is simply not the case. And I would hope that the questions that I asked both the attorneys today indicate that I am always open to information. And when you submit that information and it relates, Ms. Kassad, to the relevant laws or rules, and there's legal support for and factual support for those, that dictates my decision. So thank you so much for attending this hearing, and I will issue my decision accordingly. Thank you. We'll close this hearing.
Thank you.